Hey, 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 it's your girl, your favorite paralegal, aka Cassandra Lynn, and welcome to Legal Doc Talk 24/7. Hope you guys are having an awesome day. I haven't spoken much in regards to Buzbee and Diddy, but I did want to bring you guys an update because, I've been kind of taking a break from this, kind of focusing on my business, but when I start to see misinformation out there, I have to respond. I've been enjoying relaxing, working, fishing, and when I'm relaxing or fishing or just in my leisure time, I tend to go on to YouTube and see what's popping. And it's so much misinformation out there, and I feel like it's my duty to put you guys on the right path when it comes to the correct information. Um, and by me just coming on here, I want to ensure that I am not just, telling you guys, but also showing you guys. With that being said, there is an update with Tony Buzbee. For one, people are still out here saying that he is not, he was barred from practicing law in the Southern District of New York and just all this stuff that's not correct. Let me tell you how the process works. In order to practice law on a state level, you have to pass the bar and gain admission to the state bar for that state, for that specific state. Okay. When you are wanting to practice in federal court on the federal level, which is the U.S. District Court in any state, you don't have to be admitted in that particular state. You can be admitted in Texas and still seek admission in a federal court in another state. So just like Buzbee is admitted in the state of Texas, if even if he was not admitted in the state of New York, he can still seek admission in whatever district, the eastern, the southern. I think there's a northern district of New York. That is how that works. Okay, so you don't have to be admitted to the state bar. You have to seek admission through that particular district court as long as you have a license, a state license to practice law in any of the 50 states. That is how that works. Now, going into the Diddy cases. So, in a motion to dismiss, Diddy stated that there were approximately 22 cases that Buzbee was appearing in, but failed to gain admission or seek admission or even his pro hoc vice application. So, I had to take it upon my liberty to actually go through all of those cases and see exactly where those cases are. And we're going to hop right on into that right now. So I have broken it down to where, and y'all can't see it because my name is on the bottom of it, but I have it set for all of the Diddy cases for the Southern District of New York. Now, these is just with Buzbee. These are not the remainder of the cases without Buzbee um, as a co-counsel in those cases. These are just the cases where Buzbee was participating in the Southern District of New York. I also have this tab where these are all the New York cases. Now, these are, as you can see, there are different attorneys. You got Tyrone Blackburn, you got Antigone Curris. I've been speaking on her for forever because I stated for you guys that even if Buzbee was not on any of these cases, there is a admitted attorney for the Southern District of New York handling these cases, and Antigone Curtis is the lead counsel on these cases. Some of these cases that you will see is either it's going to be Curtis and AVA Law Group, or it's going to be Tyrone Blackburn, or it's going to be Rachel Nicole Friedman, Mercer Law Group, Hart, McLaughlin, and Elridge, Renegold, Gafara Rufo, what is that? Alred, Morocco, and Goldberg, and DeCello Levy LLP. Now, these are just the New York cases that are against Diddy. Has nothing to do with Buzbee. Nothing. None of these New York cases have anything to do with Buzbee. Buzbee has not filed any type of appearance in these New York cases. These are the Supreme Court cases of New York, the state of New York. Now, going back to the federal district or the federal court cases, aka the U.S. district cases, only these cases is where Buzbee was participating in. Now, I have explained to you that even though he was filing these cases, that does not mean he was lead counsel. All that means is that he was drafting the documents, sending it over to Curris Law Firm, and Curris Law Firm will file it on his behalf. But when you look at a filing, it doesn't say it may say, submitted by Buzbee, but it'll show in parentheses where the filing came from. Because as I stated before, in order for him to go into the Southern District of New York on the PACER side, he would have to have been admitted or at least granted pro hoc vice in order to even pull up the filing in uh in a in the Southern District of New York. That is how that works. So as I stated before, and Antigone, and I think that's how I say her name. I always mispronounce her name. Antigone Curris, AVA Law Group, are on majority of these PI cases, these personal injury sexual assault cases. So if Buzbee is not on these cases, that does not mean that the cases are going to halt. It doesn't mean that the cases are going to be dismissed because he's not on there. That was never the case. These cases are still moving because the lead counsel is Antigone Curris, as I showed y'all time and time again. All right, Buzbee was just co-counsel. AVA Law Group was just co-counsel, but the lead counsel on these was Antigone Curris. If Buzbee was the lead counsel, it will show him at when you look up a case, it will show him as the lead attorney. So I'm gonna pick. Let me just see. I'm just gonna pick a case, and I'm gonna show y'all what it's gonna look like. So here's Doe. You go to Parties tab, and here, Antigone Curris. This is the attorney to be noticed. So if anything was to be filed in the court, Antigone Curris will be the attorney that is noticed. She will receive correspondence from the court because she is the lead attorney. Does not say Anthony Buzbee on there. Now going back to these are the 20 cases. I don't even know where Diddy's attorneys got that, but what they tried to do is they tried to hop on the bandwagon and say, hey, Buzbee is not, admitted in the Southern District of New York. We need to get these cases out of here. Apparently, somebody does not know how this works. Just because Buzbee is not admitted, that does not mean that these cases are going to be thrown out. These cases are being actively worked on by Miss Curris. These are all in order. So we have about 1, 2, 3, 4, 5, about 5 cases that have been dismissed. One of those cases was dismissed because they didn't file the complaint. I don't know what happened in that case, but when they I don't even know. Honestly, you look at the docket history and it doesn't make sense. I just know that the pleading wasn't filed. Then we have other cases. The other four cases were dismissed because they failed to file a motion to leave in order to proceed under the pseudonyms. So they filed a complaint under, either Jane Doe or John Doe, but they failed to file a motion to continue to proceed under those pseudonyms. So the cases were dismissed, but that does not mean that they can't refile. They can refile, but they would have to refile either under their names, their real names, or if they do decide to file back under the pseudonym, then it would have to be they would have to file a motion to leave. Then we have some cases where we're just waiting on the plaintiff, the Curtis law firm, to respond to Diddy's motion to dismiss. So pretty much on all of these cases, Diddy has filed a motion to dismiss. Reason being is either it's time barred or it happened outside of the New York City limits, or Anthony Buzbee was not admitted to practice law. Well, not admitted in that particular court to have any of these cases, which that is totally irrelevant because, like I said, the lead counsel is Miss Curtis. So that really shouldn't have anything to do with it. Then there are some cases where the plaintiff has to file or an amended complaint in order to carry on with the case, and that amended complaint has to have their real name. Then we have the Jane Doe case that was voluntarily dismissed. Let's see. And then, oh, this is an interesting one. So we have one case where it's a request to adjourn the conference, meaning that they're wanting to delay it. But I found something very interesting in this particular case. And I'm gonna let the cat out the bag or the rabbit out of the hat, however the saying goes. But they're waiting on Diddy's trial. Yes, yes, they are. So there was a document that was submitted, and this is the order on the motion to adjourn. Let me see. Yes. So I'm going to pull this up, and I know you guys can't read it, but I'm going to read it for you. So it reads that we write jointly on behalf of the plaintiff in this action and the defendants, Sean Combs. So they all came to an agreement, both the plaintiff and the defendant. Oh, I'm gonna reread that. Rewrite jointly on behalf of the plaintiff in this action and defendant Sean Combs, Daddy House Recordings, CEO Co. LLC, doing business as Combs Global, formerly known as Combs Enterprises LLC, Bad Boy Entertainment Holdings, Bad Boy Production Holdings, Bad Boy Books Holdings, Bad Boy Entertainment LLC, and Bad Boy Productions LLC. The undersigned parties respectfully request that the court previous ordered deadline to submit a case management plan, currently scheduled for March 9th, 2025, and initial pretrial conference, currently scheduled for March 19th, 2025, be adjourned pending resolution of defendant's motion to dismiss. All the parties believe that it will be more efficient to defer discovery pending resolution on the motions to dismiss. If these motions are successful, they may result in a complete dismissal of this action in its entirety or against certain defendants, which could significantly alter the scope of discovery that needs to be conducted. As I've always said, we have to get to the discovery phase because that is when everything comes out. And so, what they're saying is this case can be more efficient if they allow them to continue with discovery. Furthermore, this is what it says: discovery in this matter is further complicated by the impending criminal trial of defendant Sean Combs, which is scheduled to begin before Judge Subramanian on May 5th, 2025. The parties agreed that it is impractical to proceed with various aspects of fact discovery involving Mr. Combs until his criminal trial is concluded. Deferring a case scheduled pending the motions to dismiss will therefore have the added benefit of allowing time for the criminal matter to conclude. And so I think I misspoke. Pretty much what they're saying, yes, they want to continue with discovery, they want to reach it to discovery. However, they're not going to get much discovery only because there is a criminal trial pending. And where's all the discovery is with the government, the prosecution team. So that's what it says. So they want to go to discovery. However, it's going to be a little bit complicated because everything that they need in order to move this case along is with the prosecution office. And, whoever, the Homeland Security, the FBI, whoever played a part in this, that is where all of the discovery is. So what they're asking is for the court to pretty much hold off, put the case on pause until the criminal trial finishes, and then they can pick up this particular litigation case. And I see this letter was also filed in another case. So so far 2 cases right now they're asking to actually hold off until the discovery um the discovery well, not the discovery, the criminal trial for Combs actually goes forth. And guess what, they actually, let me see. Yes, so the judge did grant it. It says the parties' joint request is granted. The March 9th deadline for the parties to submit a case management plan and the March 19th, 2025 initial pretrial conference are hereby adjourned sine die pending resolution of the defendant's motion to dismiss. And then both of the defendants and Curtis law firm uh, did come to that agreement. So this case is going to be adjourned. Okay. Well, adjourn the conference. Now, going back to this, let me see. Case was terminated. Oh, and then in this particular one, so there was another case where Buzbee actually decided to, and I need to show y'all what Buzbee stated on his stories. Because, like I said, I always said that he is playing chess, not checkers. Y'all have to be able to know that my boy, he got it. He got it. But people don't have faith in him. That is the sad part. That is the sad part. All right, so going into this next case, if I can get back to the screen that I need to get back to, there we go. Buzbee withdrew his appearance in this particular case. This does not mean that the case is not going to go forward. You want to know why? Because if we go to the parties tab and we go to John Doe is being represented by the lead attorney, Antigone Curtis. She is the attorney to be noticed. Okay? She is the attorney, she is the lead attorney on this case. So, although he decided to withdraw his appearance, he had to do that only because he was filing in this particular case. Just like this right here. So, we have the declaration of Anthony Buzbee, right? But as you can see, it shows Curtis. Once again, because Buzbee does not have a login for the Southern District of New York because he has not been admitted in that district. So because he was filing things, he has to now withdraw that. So he withdrew his appearance. And I'm going to go to the document that shows this. So he filed this yesterday. And it reads that please take notice to pursuant to Local Civil Rule 1.4b, Anthony Buzbee, an attorney for the plaintiff in the above captioned action, hereby moves to withdraw his appearance as an attorney of record until such time as he is admitted to practice in this honorable district. Plaintiff will continue to be represented by remaining counsel of record from Curtis Law Firm. I've told y'all time and time again, once again, Curtis Law Firm is local counsel. She is the lead attorney for all of these, majority of these cases. Co-counsel is Buzbee and AVA Law Group. I can't say that enough. Let's see. What other did I see on here? And I think the next thing that I want to show you guys is the response, because there were a couple of cases where Miss Curtis actually responded. And like I said, all of these cases that are on this spreadsheet for the Southern District of New York, Combs has filed a motion to dismiss. So he's filed a motion to dismiss. Now, I have not seen or gone through the New York state cases to see if he has done the same in those cases, because he does not go hard on these state cases like he does these federal cases. But I want to show y'all a letter that I thought was pretty interesting. Is this the letter? Okay. So this is the letter that Miss Curtis filed in another case, I believe two other cases, in response to Diddy's motion to dismiss. And it reads that rewrite on behalf of plaintiff John Doe in response to Sean Combs and all of his entities, letter motion dated February 25th, pursuant to which defendants request to leave to file a motion to dismiss plaintiff's complaint. The defendants intend to move for dismissal on the grounds that 1, the complaint is time barred, 2, the plaintiff's GM, that's the gender motivated violence claim, fails because it does not allege the required element of gender animus. 3, the claims against the company defendant fail, and the company complaint lacks evidence of specific conduct by the company's defendants. And 4, that the claims against CE Opco LLC, Bad Boy Entertainment LLC, and Bad Boy Productions LLC fail because they were formed after the alleged sexual abuse. The defendant's argument that claims are time barred and that the company are essentially shielded from liability are both baseless. The crux of defendant's argument pursuant to Federal Rule 12b-6 is that the VGM VPL cannot apply retroactively against corporate defendants, and that plaintiff claims regarding sexual abuse he suffered in 2001 should therefore be dismissed. In support of their arguments, defendants rely on Doe versus Combs, wherein the court held that 2022 amendment to the VGM VPL, which expanded the scope of liability so as to apply to any party, cannot be applied retroactively against corporate defendants because the original VGM VPL applied only to any individual. So they're trying to pretty much what they're trying to say is that the corporate or the companies have nothing to do with how Combs act. So just throw away the whole case. Let me tell you something. If they are funding his little rendezvous, they are much more at fault than just the individual himself. Originally enacted, the VGM-VPL provided victims of gender-motivated crimes of violence with a cause of action against only the individual who perpetrated the crime. Effective January 2022, the City Council amended Section 10-1104 to provide any person claiming to be injured by a party who commits, directs, enables, participates in, or conspires in the commission of a crime of violence motivated by gender has cause of action against such party. In the same enactment, the City Council also amended Section 1105 entitled Limitations to provide any civil claim or cause of action brought under this chapter that is barred because the applicable period of limitations has expired is hereby revived and may be commenced not earlier than 6 months after and no later than 2 years and 6 months after September 1st, 2022. Taken together, the two amendments: one, expanded liability for non perpetrator defendants where no liability had previously existed, and two, revived causes of action brought under the statute whose limitations period had already expired. Neither Section 101104 nor Section 101105 have express provisions that apply the VGM VPL to causes of action accruing before its 2000 enactment. Defendants' arguments are contrary to the VGM-VPL's primary intention to make it easier for victims of gender motivated violence to seek civil remedies in court, not as defendants would have it make it harder. Let me see. They stated that New York City passed the VGM VPL in light of the void left by the Supreme Court's decision in United States versus Morrison, in which Morrison struck down the federal right of action for victims of gender motivated violence under the Violence Against Women's Act, holding that Congress lacked the authority under the Commerce Clause in the 14th Amendment to pass such a remedy. So the purpose of this, the VGM VPL, was to make it easier for victims to seek civil remedies. Think about it. If the statute of limitations for the criminal portion is gone. So in order for them to get some type of justice, they have to go through the civil way. So a lot of people be like, well, why don't they just press charges? Da 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 da. Y'all have to realize that there is a statute of limitations when you're dealing with criminal and you're dealing with civil. But with civil, it's a little bit more, I don't want to say lenient, but it's easier to do because the time, as you can see, is expanded. They allow them enough time or extend the time to give them that option to seek justice the civil route. Let's see. She also stated that it is fundamental that in interpreting a statute, the court should attempt to effectuate the intent of a legislator. And Caddis Jones, let's see, it says holding VGM VPL was intended to apply retroactively, because that's what Diddy is saying. Like you can't go back, but this particular act is intended for things to apply retroactively. The council intended for VGM VPL to make it easier for victims of gender motivated violence to seek court remedies. It intended the same when it passed in 2022 amendment to the law. Let me see. Based on an analysis of statutory text and history, it is clear that the legislative body intended the VGM VPL to apply retroactively. Based on the foregoing, it is apparent that the complaint is not time barred and the claims against the company defendants are valid. Moreover, the crux of the company's defendants' arguments for dismissal pursuant to Rule 8 is the plaintiff's allegation against the company defendants are too vague to meet Rule 8's fair notice requirement. Plaintiff respectfully submits that the company defendants' arguments are without merit. Rule 8 is a fashioned in the interest of fair and reasonable notice, not technicality, and therefore is not meant to impose a great burden upon the plaintiff. Here, the complaint alleges in pertinent part as follows. So this is what the complaint reads. The Combs corporations further enabled and conspired with Combs to commit the crimes of violence motivated by gender by actively placing, maintaining, and or employing Combs in positions of power and authority, despite the fact that they knew and should have known that Combs had a widespread and well-known practice of committing sexual assault and gender-motivated violence, including on premises owned and or operated by defendants. Combs used his titles and authority conferred by the Combs businesses, including as CEO, founder, and chairman, to facilitate and perpetuate the violent assault on plaintiff and to intimidate the forced plaintiff to keep quiet in subsequent years. In light of the foregoing, it is respectfully submitted that plaintiff has plausible pleaded on the face of his complaint that he suffered harm from the company's defendant's action, and that is enough for now. Furthermore, as discovery has not been exchanged nor have the parties been deposed, it is premature for the defendants to allege that the complaint should be dismissed for allegedly failing to establish gender animus. That is what I have been saying for in any other cases. As soon as they receive a copy of the complaint, they move to dismiss the case. Nobody has been deposed. No discovery has been exchanged. You have to allow the plaintiff to go through this process. And I know it does suck. Nobody wants to go, but when you're going back and forth with all these motions and it'd be different if there was no legal claim or if they didn't state a claim. Then yeah, of course dismiss the case. But claims are stated. Kurt's law firm, everybody be ruling her out, but she is bomb. She is bomb, and she's laying it down in this notice. Let me see. What else did she say? Da, 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 da. Under the GMVA, a crime is motivated by gender if it involves an animus based on the victim's gender. Courts have repeatedly held that sexual violence inherently demonstrates gender based animus. Let me see. I'm just trying to make sure that I get okay. So, without consent, sexual acts are in violation of the victim's bodily anatomy and an expression of contempt for that anatomy. Animus inheres where consent is absent. In Engelman versus Rufus states that found gender-based animus in sexual assaults involving groping and coerced sexual acts. Here, plaintiff alleges acts of sexual violence, including oral and oh my gosh, where the sun don't shine penetration that dehumanized him and disregarded his anatomy. Such acts clearly demonstrate gender-based animus. Additionally, despite defendant's argument that the claims against CE Opco LLC, Bad Boy Entertainment, and Bad Boy Productions failed because these entities were formed after the alleged sexual abuse, it is plaintiff's position that the successor liability applies and therefore the case should not be dismissed as against these defendants. And it's crazy. So what are y'all saying, that the abuse did occur, but y'all don't want these companies involved in it because they were created after the sexual abuse, the alleged sexual abuse? Anywho's, um let me see. The core, let me see. They just cited another case. So I did I already read that. Okay, so Smucker versus Richard Shear Company, they state in which the Court of Appeals held that a successor corporation or entity and or an entity which is formed as a result of a merger could be responsible for the liabilities of the predecessor entity. The court stated a corporation may be held liable for the torts of its predecessor if one, it expressly or impliedly assumed that the predecessor's torts liability. Two, there was a consolidation or merger of seller and purchaser. 3, the purchasing corporation was a mere continuation of the selling corporation. Or 4, the transaction is entered into fraudulently to escape such obligations. In Simpson versus Ithaca Gun Company, it states there that the court stated that the premise that a successor corporation may be responsible for liabilities of a predecessor corporation is based on the concept that a successor that effectively takes over the company is in its entirety, should carry the predecessor's liabilities as a uh, con, con wait concomitant to the benefits it derives from the goodwill purchase. Sorry, I'm trying to read this in a small. In light of the foregoing, plaintiff respectfully requests that the court deny defendant's request to file a motion to dismiss in its entirety. So pretty much what they're doing is the they are wanting to, and when I say they, the defense is wanting to file a leave so that way they can file a motion to dismiss this case. So in some cases they have already done that and they were able to file their motion to dismiss. But the way that it works in the federal courts is that the defense will file the motion to dismiss, the plaintiff will reply to the motion to dismiss, then the defense will reply to plaintiff's reply. It goes back and forth. And then that's when the judge come in and says, they'll read both arguments and then they will make a determination as to, if the motion for, to dismiss the case will actually be granted or denied. But overall, I just want to come on here to kind of give you guys a glimpse of the 20 so often cases that Diddy tried to mention in one case to try to get this, all the cases, well, that case as well as the other cases to be thrown out. Let me tell y'all something. It's not going to work. He tried to pull a Jay-Z move, and that's just simply not it. Do you know why that's not going to work? It's not going to work because, as I stated before, as you can see, the Curtis law firm is the lead attorney on majority of these cases. All the cases that were filed, even though that there were some were dismissed, the Curtis law firm was and is the lead attorney. They are the attorney of record. They are the attorney to get notice whenever there is an update or correspondence to the docket. Even if Buzbee was still on this case without the Pro Hoc Vice or without the admission to the Southern District of New York, even though he shouldn't been doing that, everything was going through the Curtis law firm because she has the admission to the Southern District of New York. She has the login. Buzbee doesn't have a login. AVA Law Group does not have a login. Plain and simple. That's how that works. When he gets admitted, then he will get access to the Southern District of New York, and then he will be able to do his filings. But I just want to show this to you guys so you guys will understand that just because Buzbee is not on these cases, I know there was one case where he filed his withdrawal and it was actually granted. It was granted today. But even though he's no longer on that case is still going to go forward, just like any of these cases that I have listed here. It doesn't stop the show. Just because he didn't get admitted or he's in the process of being admitted, but just because he didn't do any of those things that he was supposed to do, that does not mean a case is going to get thrown out. That does not mean that a case is not going to be worked on because lead counsel is the Curtis law firm. Antigone Curtis is the lead attorney on these cases. Co-counsel just means that everybody is sharing the work. Because there may be something that y'all have to understand. Even though she's a PI law firm, I don't know, I've never seen her in trial, but the Buzbee law firm are trial attorneys. There is a difference, as I explained to y'all time and time again. There's a difference between a litigation attorney and a trial attorney. Some litigation attorneys never make it to trial. It goes from filing the complaint to possibly mediation. And if they settle, that's it. But if it goes to trial, then you need somebody who has trial experience. And that's what Tony Buzbee is. He is a national trial attorney. So always remember this. Litigation attorney is different than a trial attorney. And if you ever have a case going to trial and you need a trial, you need to ask your attorney, have they ever been to trial? What is their success rate at trial? Because if there's plenty of attorneys that I know that do no, there's actually, I'll take that back. There's a lot of attorneys that do pre-litigation. They don't even file a complaint yet. They don't even start the lawsuit. You have those type of attorneys. And usually those are the baby attorneys that been licensed for a couple of years. Then you have some attorneys that only do litigation. They never go to trial because they end up settling cases. And I'm talking about civil, I'm not talking about criminal. They end up doing, you know, settlements before it even gets to the trial phase. Because if you cannot settle after mediation, that's when you start prepping for trial. And then you have your trial attorneys. So be mindful of that. Be very, very mindful of that. So Buzbee is okay. Buzbee is playing chess. He's not playing checkers. Buzbee is strategic. And I'm only referring to this particular the Southern District of New York cases. So just because he withdrew from one, that does not mean the case is going to be dismissed. It doesn't mean that the case is going to fall apart because there were already attorneys on the cases. Okay? If y'all have any questions about the procedures, the process, definitely leave them in the comments below. But this video was to show just that. The Curis Law Firm is the lead attorney for those 20-something cases that Diddy is claiming Buzbee didn't seek admission. That's irrelevant. That is totally irrelevant at this point. So he thinks that is the key to getting the case dismissed. Now in your motion, you're saying like it's time barred, the Gender Motivated Violence Act, that has nothing to do with it, so on and so forth. But as soon as you heard that Buzbee was not admitted in the Southern District, New York, you thought that was a way to go. Like, oh, that right there is the nail in the coffin, and it is not. Your case is still going to go on. Now, we do know that there are two cases where they are actually being adjourned and they're going to play out to see what's going on in the criminal trial. Because if they need discovery, how can they get discovery when that discovery is being used in a criminal proceeding? Huh. So, y'all let me know what y'all think about this in the comments below. Don't forget to like, share, and subscribe. Until then, you all be blessed and I'm out. Bye.